And we'll just leave it as is. I'll turn the recording off and restart it when we reconvene at 12:30.
Barbara had her hand up, Brian, I thought.
Okay, Barbara?
I'm now got your sign on the screen. It's sort of distracting. I just wanted to add on the Public Records Act bills. It's clear that at least for some, perhaps all of the entities that were saying they were in opposition to the bills, that the opposition was based on the current COVID situation, and that their position likely would change back to a neutral stance once the COVID situation and the resulting financial impact improved.
You know, I would just add, not to take our COVID pandemic discussion back, but that's certainly an area of concern, is having to respond to a Public Records Act request when you're working remotely in a pandemic. So it's probably an area ripe for some help.
Yeah. Okay, we'll see you all at 12:30.
Okay, hello everyone. It's now 12:30 according to my atomic clock program on my phone. So we're going to reconvene the meeting. Thank you for coming back after lunch. We skipped an item earlier in the agenda, so let's go back to the item on our handbook, which is a housekeeping matter, before we get to substantive issues. Brian, let's review Memorandum 2020-10 on our handbook.
Okay, this addresses just a narrow issue on coordination between the Commission and the Committee on Revision of the Penal Code. When that committee was created, it was structured within a state budget as an element of the Commission. There was no differentiation within the budget itself. So we still, notwithstanding the fact that we got some new people and some more money, we still only have one program in the budget and a single appropriation for that program. So that at least raises the possibility that there could be conflict between the Commission and the committee as to how to spend the budget or use the staff resources. Because there's no, like I said, no clear division within the budget itself that allocates a certain amount to one versus the other. nor is there any clear hierarchy of authority between the two bodies. I mean, the commission certainly has historical primacy. You were here first. This other thing was added, but there's nothing in the statutes that says how to resolve any kind of allocation issue. So at a prior meeting of the committee, I suggested that they add a provision to their handbook along the lines of what's shown on page 1 of this memo, which they did. And it says, before proposing any extraordinary expenditure of funds or other resources, the chairperson will consult with the executive director about the effect of the expenditure on the Law Revision Commission. The executive director has sole discretion to require that the expenditure be approved by the Law Revision Commission before it is made. The Law Revision Commission shall not unreasonably withhold its approval. For the purposes of this section, extraordinary expenditure of funds or resources means an expenditure that exceeds the allocation to the committee provided in the state budget. So while there is no formal division within the budget, it is clear that a certain amount of money and a certain amount of staffing was added to our budget for the purposes of the new committee. And that sort of sets a baseline ratio of the resources that the commission had prior to this change and the resources that existed after the change that were added for that purpose. So basically, this is sort of a negotiation provision just in case things go wrong. I don't anticipate that they're going to go wrong, but I anticipated the possibility that at some point the committee might want to hire a consultant who's going to charge more, that would an amount that would exceed what was allocated for their purposes when they were added to our budget, and that would necessarily eat into the resources the commission has. So this was put in there just so that if that were to happen, there'd be a backstop. They'd have to talk to me. I'd have to look at the issue and see whether I thought it was a problem. And if it was a problem, I'd have to bring it to the Law Revision Commission for your assent to basically allow them to overspend by measured against the original allocation. When I put that on their agenda and proposed it, I said I would also suggest that the commission adopt a reciprocal provision for our handbook. And that's what's shown on page 2. And it really is just the mirror image, just the names are substituted around. So if you wanted to spend money that would eat into the money that was allocated by the legislature for the committee's purposes, I would be in a position to say, hey, wait, you know, this exceeds what the legislature contemplated. I'm going to have to go to the committee and get their blessing on this. And so it sort of presumes that you get what you originally had, but with an escape valve that, you know, if there's a situation where you don't care about them overspending for some reason, then it's permitted. But it's sort of like a reasonable accommodation, not with a lot of teeth in it. It's, you know, and the alternative that occurred to me would be to suggest that the budget be more formally divided. But I just generally disfavor anything that's going to tie my hands. In the absence of a demonstrated problem, I didn't really want to say, hey, let's make things more difficult. Let's give me less flexibility. So this was designed to preserve the existing flexibility while allowing a veto of one body if the other one wants to overspend. So the question before you is whether you want to add this to the handbook.
And I note, Brian, it says that you're personally liable for
Yeah.
any expenditure in excess. So that's a backstop or control over any wild spending by you.
Yeah, or you. I mean, if the commission or the committee decided to spend money that exists in the budget, I would have to make it up.
Right. Any thoughts, commissioners? Do you need a motion? Do you need a motion to vote, Brian, or just general thumb waving?
I see a hand.
Oh,
Commissioner
okay.
Simpson.
Sorry, didn't see that. Commissioner Simpson.
So this, the provision that's reciprocal to the one in our handbook is in the Law Revision Commission, the Penal Code Committee's handbook? Okay.
Yeah,
So
they've added it.
okay, so we're basically conforming to what they would.
Right, we're
already
creating bookends.
Okay, got it. So with that, I will move approval.
Second.
I'll
Okay.
second.
Okay, all those in favor say aye and raise your hand. Aye.
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 Boyer Vine, are you present or are you?
I'm presuming not.
Okay. All those saying no? Seeing none, any abstentions? None, and you'll be marking Boyer Vine and Chow as not being present. Very
Correct. And that completes that. Thank you.
good. Very good. We're going to turn to substantive matters now, and let me repeat what I said at the beginning of the meeting. Any audience members who are from the general public, if you could signal before, as soon as possible earlier, that you will be commenting on something, please do so by pressing the raise hand button on your screen. And that way we'll have an idea of who wants to speak. Of course, if you didn't do that at the beginning, you're free to do that during the discussion, but it'd be helpful to know in advance if we do have a lot of people who want to chime in. With that said, let's move on to the substantive matter of eminent domain pre-condemnation activities, Memorandum 2020-12.
All right, that's mine. Hello, everyone. Hope the sound is okay. This memorandum presents a draft revised tentative recommendation for the Commission's approval that incorporates all decisions the Commission has previously made in the study, a handful of proposed technical revisions proposed by the staff, and 2 other conforming revisions discussed in the memo that the Commission has not yet seen. It's labeled a revised tentative recommendation because the Commission had previously circulated an initial TR in the study addressing a single issue that is incorporated in this draft TR. That was back in 2017. So the study concerns, just as a very brief recap, the study concerns a part of eminent domain law relating to 2 different types of harm a property owner can suffer caused by a public entity that is contemplating the commencement of an eminent domain action, but which has not yet done so. The first type of harm is that caused by pre-condemnation activity conducted by the entity on the owner's land, which is generally used to help the entity decide whether or not to commence the eminent domain proceeding. And the second is caused by unreasonable conduct on the part of the entity after it announces an intention to commence a proceeding, but before actually doing so. That harm is called informally clopping damages by case law. All right, starting with the first type of harm, which is the pre-condemnation activity on the owner's land. The eminent domain statute, which was enacted by the Commission or on Commission recommendation many years ago, has a number of provisions relating to that pre-condemnation activity. In 2016, the California Supreme Court ruled that one of those provisions that relates to how an owner can get their compensation for that harm was constitutionally deficient because it failed to provide the owner a right to a jury trial as to the amount of the compensation. However, rather than strike the whole procedure, the Supreme Court judicially reformed that provision to afford the owner the option of having a jury trial. And because that reform created a significant inconsistency between the text of the provision and its judicially declared meaning, the Commission decided it would be helpful to recommend a revision of the text of the provision to conform to the holding of the Supreme Court. So if you turn to the draft revised TR and turn to page 7, this provision, which the Commission has decided to revise, is Code of Civil Procedure section 1245.060 subdivision C. And you can also see there how the Commission has decided to revise the provision. And I need to turn to it also. Does anyone have any questions about this revision? Okay. So staying with this first type of harm for pre-condemnation activity, the Commission also decided that to promote efficiency and conservation of judicial resources, an owner should be permitted to, as an alternative to seeking compensation under 1245-060, to instead seek that compensation in the owner's answer in a subsequently commenced eminent domain proceeding. So in other words, rather than seek it in the pre-commencement proceeding for compensation, the owner could wait and then make a claim for it when the eminent domain proceeding is commenced. And so that decision by the commission allowing that alternative is reflected again on page 7. Lines 19 and 20, we've added some text which provides this option. This is still in 1245-060, and now it's in subdivision A. And then on page 8, we have added to the provision that talks about the content of an owner's answer in an eminent domain proceeding, and added a new subdivision C. Any questions about these revisions? Turning to the second type of pre-condemnation harm, the clopping damages. This type of damage is awarded to an owner, but it's only provided for by case law. There's nothing in the statute right now that talks about it. The commission, one of the commission's reforms was also to add or to codify this case law and provide that an owner must seek these damages by adding to the owner's answer in a filed eminent domain complaint. So still on page 8, that would be the new subdivision D to section 1250-320. You can see it on line 21. Questions about this revision? Okay, moving right along. The staff has proposed 2 conforming revisions that the staff felt would be helpful and perhaps necessary in light of these decisions the commission made. And these have been discussed in the memo, but have not yet been presented to the commission. You can see these on page 9 of the draft TR. These are revisions to section 1260.230. This provision, the intent of this provision is to require a trier of fact in the eminent domain proceeding to separately identify in any award that it makes the amount of that award that's attributable to different types of statutorily authorized compensation that the owner has claimed. So because our recommendation would add statutory authorization to seek 2 additional types of harm, these 2 types of harm based on pre-condemnation activity, it appeared to the staff it would be consistent and appropriate to add these 2 types of compensation to the list of other statutorily authorized compensation in 1260-230. So this is new to the commission. It was explained in the memo, and I'm happy to take any questions about it. Or does the commission approve this as well? Does this appear to be appropriate as well?
Steve, I don't feel very strongly about this, but I note that on that point, subsection D and E, there's no description of what subsection C and D are, whereas the other ones you actually have like a little summary, compensation for loss of goodwill and amount of benefit and so forth. For parallelism, should there just be like a couple of words there?
Well, what's everyone's thoughts? I think that we considered this in part. So if we look at 1250-320, so that would be the summary. We would have to summarize what we've added in C and D. And I think at least for subdivision D, I'm talking about 1250-320D now on page 8. The thinking was that it would be somewhat difficult to summarize that in any abbreviated fashion.
Okay, fair enough. That's fine. I just noted that there's less verbiage on those.
There is a little bit of inconsistency there. And, again, this is a TR, so who knows? Maybe we'll get some comment, asking about that. Any other questions or concerns about this revision on page 9? Okay, and so it seems like the commission is approving the inclusion of that revision for purposes of the draft revised TR. That's the sense I'm getting. Okay, so The remainder of the revisions that you see in the draft are technical corrections. I won't go over them individually, but this is the opportunity to discuss them if anybody saw anything that they wanted to point out or discuss or had a concern with. Okay, seeing none. Next to last in this presentation, apologies from the staff. The text of 2 comments as they appear in this draft require minor revision to address typographical errors. Sorry about that. On page 8, line 29, we have a little bit of extra verbiage here. The word if on line 29 should be removed, and the comma on line 30 should be removed, so that the first sentence here reads, subdivision D is added to provide that any claim for loss caused by the plaintiff's unreasonable conduct prior to commencing the eminent domain proceeding must be included in the defendant's answer. I think we had started to word it slightly differently, and we didn't quite make the complete change. And then, even more minor, on page 9, line 9, we have 2 transposed digits here. The section number that's referenced there in the comment should be 1260.230 rather than 320. And the very last thing is that because this draft revised TR was scheduled to be considered by the commission in March, on the cover, we have a requested due date for return of comments, which is May 29th, obviously too soon. So this date needs to be extended, and the date the staff would propose would be August 13th. That is 4 weeks before at least what's right now scheduled to be the commission's September meeting. So it would give a fair amount of time for comment, and would then give enough time for the staff to analyze whatever comment was received and still get it to the commission in time for the commission to make a decision at the September meeting. Any questions, concerns about any other aspect of the draft that has not been discussed? Okay.
Steve, do you need a motion and a vote on all this?
We do. In fact, a roll call vote we need because it's a recommendation. With the incorporation of the typographical corrections and the change in the date that I've mentioned, does the commission approve this draft as a revised tentative recommendation to be circulated for public comment?
I have a motion on that.
So moved.
Second.
Okay, there are no audience chiming in, and any discussion? Seeing none, all those in favor say aye and raise your hand. Aye.
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 All those opposed, say nay and raise your hand. And any abstentions? Seeing none, the motion is carried. Thank you very much, Steve.
All right, thank you. Bye for now.
Okay. Next, we go to recodification of toxic substance statutes, Memorandum 2020-13. Any audience members who wish to be heard, it'd be helpful if you chime in. Okay, we have one taker. Let's go ahead and start before we go to that audience member.
Okay, yeah, so that's going to be Rick Broush from DTSC. He's the staff liaison that I've been working with. And so I expect that he'll have some good feedback to offer through this process. So Memorandum 2020-13 discusses the next steps on the Commission's study to recodify the toxic substance statutes. As the Commission will recall, back in January at their last meeting, they approved a tentative recommendation to recodify Chapter 6.8 of Division 20 of the Health and Safety Code. In the Commission's assignment from the legislature identified 2 chapters, Chapter 6.5 and 6.8. So the natural next step is to start in with Chapter 6.5. The memo primarily is discussing Chapter 6.5 and its contents. One of the things that I wanted to mention up front is the Commission also has authority to study related provisions. One of the first issues that the memo discusses is whether or not there might be some related provisions that are located in or around Chapter 6.5 that should be recodified with Chapter 6.5. The Commission may recall early on in this study, we got feedback. We were proposing to move these two chapters out of their current location later in the Health and Safety Code. And one of the concerns was right now they're located in and amongst a bunch of related substantive law. So the question that we pose for stakeholders is whether or not some of that substantive law is actually so interconnected with Chapter 6.5 that we should be looking at it together with Chapter 6.5. And hopefully we'll get some feedback and comments on whether we need to do that. The next thing the memo discusses is the drafting practices, and those are all presented as consent items. These are essentially the same drafting practices that the Commission used when they were recodifying Chapter 6.8. They are effectively, the staff is taking a very light touch. We're trying to stick with the existing language as much as possible because one of the restrictions on the Commission's authority is that we are only allowed to make non-substantive changes. So to avoid the possibility of making substantive changes, we're trying to just use the language that's there as best we can and make minor adjustments and reorganize things, move the pieces around. So if there are no questions or concerns about the drafting practices from the commissioners, that's going to be treated as a consent item. I'm going to take just a final vote of the Commission to move forward with this at the end. The next item is the content of 6.5. So Chapter 6.5, I think when it was initially introduced, related to hazardous waste and the regulation of hazardous waste. It's generation, transportation, disposal or treatment. So all the rules were kind of focused on that piece. Since then, the chapter has sort of grown and changed a bit. A lot of newer laws have been added that relate to pollution prevention, trying to keep hazardous materials from entering the commerce stream altogether. So there is quite a bit of material in Chapter 6.5, and some of it is closely related. Other things seem like they're pretty different in terms of how they might work. The memo includes an exhibit that has the list of existing chapter or articles in the chapter, just for the Commission's information about what's there. I will say there is a lot more statutory language in this piece. Chapter 6.5 is quite a bit longer than Chapter 6.8. From one annotated code book, we have about 5 times as many pages of law. So it's a lot. And I guess the main thing that this memo presents is a proposed provisional outline for the organization of the recodification of Chapter 6.5. That's presented on exhibits pages 3 through 5. So that outline is intended to show what we anticipate the recodified law looking like, and it shows where we think the current pieces of Chapter 6.5 are going to fit in that organizational scheme. I want to emphasize it's intended to be provisional. There's a lot of law there. I kind of took an overall look, but I haven't gotten into the details yet. It's very likely that some of the pieces are going to need to change. Some of the provisional titles that I've suggested are probably not quite the right fit. So I'm actually hoping DTSC, if we can get Rick his line activated now, I think that's probably the thing that they'll want to talk about. I don't know that they have any specific feedback on changes at this point, but I do know that they are looking at this closely and there are things that they've identified and are thinking about.
Okay, the chair recognizes Mr. Rick Brosh.
Okay.
You are still muted. Okay, there you go.
There we go. All right. Well, thank you very much for the invitation to speak. And we're also looking forward to this process. Your staff working on this project have been very cooperative and very open to hearing our suggestions and feedback, and we've appreciated the interaction with her. We also agree with her that the new phase of the project here with Chapter 6.5 is going to be much more challenging than the previous Chapter 6.8 portion. Regarding the memo, we've got no concern with locating Chapter 6.5 in the location you suggested. We also believe that the related provisions. There's a couple of chapters that we think should be considered, although, I mean, there's arguments for and against those particular chapters as well. For instance, chapter 6.66 related to oversight costs. It relates to both chapter 6.5 and 6.8. We understand why it wasn't moved with 6.8, but we think that it may, now that 6.5 is moving in the same fashion, that it may make sense to look at that one as well. And in addition, chapter 6.11 related to the Unified Hazardous Waste and Hazardous Materials Regulatory Program. It relies heavily upon chapter 6.5, but it also relies in part on other statutes that are in that basic vicinity. So it's going to be a kind of a choice between who you inconvenience and or make more convenient in this process. And we recognize that. And it's probably no easy decision here. Regarding the drafting approach, we have got no concern or issue. We saw that successfully played out previously, and I think it works for us. And then generally, with respect to the proposed organization structure, we have no concern with it, although we may have thoughts on the new chapter name and its various chapter provision titles as the project proceeds. As I think staff mentioned, the evaluation in each of those articles that are currently in chapter 6.5, it seemed as though they were just a basket within which various things were placed. There is not a true organization once you dig deeper beyond the surface of those. So I think as this process progresses, we'll need to kind of keep that in mind, and I will be working with your staff to do so. The other aspect on the organization, while we understand and believe the separation between waste-related and product-related provisions makes perfect sense, we also need to ensure that some of the general provisions that broadly apply are preserved. For instance, the enforcement provisions, which equally deal with both product and waste provisions, we need to ensure that we don't lose anything in that process, because the enforcement of both bodies of law will be critical. As staff has already noted, the current organization and titling belie the complexity and varied content. There are things related to financial as well as technology, as well as other, like I said, hodgepodge features in each of the articles that we'll need to work with. Another example is the financial provisions. Currently, as the organizational structure points out, it's looking at the sections that establish our main accounts that we use for funding our activities. But there's also other features related to finances that assess fees, for instance, in Article 9.1, and also relate to cost reimbursement in Article 9.2 that may be considered for moving into that area. But anyway, at this point, like I said, we don't have any more detailed comments. Like I said, I think it's going to be a kind of an evolving process. We look forward to working with your staff in this process. Like I said, there's a lot of information there, a lot of statute, and we will be fully engaged throughout this process. So I thank you for the opportunity to testify.
Thank you. So Kristen, are you looking for the commission to tentatively approve the proposed organization?
Yes, and just with the recognition that it is provisional, and like Rick mentioned, some of these things are probably going to need to change as we get more familiar with the details, as we get additional feedback. So with the understanding that the organization is not going to look exactly like it looks on paper today, but that this is going to be sort of a work in progress, and it will move and change. It's intended to just be a guide. It would be good to get the commission's approval to sort of move forward with work. If the commission would like, I can sort of walk through kind of big scale what the organization is. Otherwise, if the commission's comfortable just taking a vote on it now, that would be fine as well.
Commissioner Borivine.
I was wondering, Kristen, with respect to the last speaker's suggestion that you look at 6.66 and 6.11, is that something you're going to consider, or have you looked at it and decided not to?
So I haven't looked at those yet. Like I mentioned, there's about 20 substantively related chapters in and around 6.5 and 6.8. So I haven't looked at those specifically with consideration about whether or not to do those with 6.5. But I can do that. And I do anticipate that once we get to the end of 6.5, that will be another time that I'm recommending that the commission go back and consider whether or not, even if those chapters don't fit in with 6.5, whether or not we might want to proceed with work on those chapters once we finish the work on 6.5. It might be that we want to do those in another phase. I just don't know at this point.
Okay, I'm a little confused as to how the motion will be worded though, because I guess on the one hand, you're still working on it. So, and on the other hand, you want some sort of authority to go forward. So do you really need a formal roll call vote, or should you just go ahead and go forward and then we'll see what shapes up?
So no, I don't need a formal roll call vote, but I do just want to get the sense of the commission, whether everyone's comfortable with me proceeding with work on this topic based on the provisional outline that's offered and placing Chapter 6.5 in the proposed location, which is a new Division 45, I believe. I don't have the number right in front of me. New Division 45, yes.
Okay, anyone opposed to that? I'm okay.
Okay.
And
Looks like everybody's okay. Any abstentions or concerns? Okay, that's all I've got.
very good. Thank you very much. Okay, now we're turning to the next agenda item, statutes made obsolete by trial court restructuring, Memorandum 2020-14. Any audience members, please raise your hand so we can get a count. Go ahead.
Okay, so earlier this year, the commission released a discussion draft that solicited comments on whether, and if so how, to revise 3 acts that relate to financing of regional justice facilities, and to revise those acts to reflect the trial court restructuring reforms that happened around the turn of the century. That procedure was a deviation from the commission's usual study procedure, in which it develops a tentative recommendation before making extensive efforts to obtain comments. The commission took that approach because it seemed particularly difficult to update these particular acts to reflect trial court restructuring without getting entangled in policy questions that might be beyond the commission's authority in this study. The discussion draft was distributed to the commission's electronic and traditional mailing lists for its work on trial court restructuring. The staff also made special efforts to reach out to each court and each county that's affected by the 3 pieces of legislation in question. And this memo for today presents and analyzes the comments on the commission's discussion draft. The commission received 6 comments, plus some indirect input from the County of Los Angeles. Some of the comments suggest repealing one or more of the acts in question. For instance, the Ventura County Superior Court says that the County Regional Justice Facilities Financing Act, that's the one that applies to Ventura County and several other counties, is obsolete and should be removed from the codes because it's no longer relevant. And San Bernardino County and the San Bernardino County Superior Court take a similar position. They say essentially that the acts are no longer needed and it would be a waste of time to try and update them carefully to reflect the changes that were made by the trial court restructuring reforms. Some other countries are more neutral about whether to repeal the acts or retain them. Los Angeles County Superior Court and Los Angeles County are in that category, as well as the Judicial Council. So there was only one commenter who expressed real interest in modernizing any of these regional justice facilities acts. That was the Humboldt County Superior Court. And so the act in question is the same one, the County Regional Justice Facilities Financing Act. And the court feels strongly that the status quo is not the solution. The court's main concern seems to be, and I'm quoting from the cover letter here, there is an ongoing need for the county to consider the needs of the court when planning, designing, and building new justice-related facilities to provide appropriate court hearing room and staff spaces if appropriate. And then the court took the time to actually propose some specific statutory revisions, which are attached to and described in the memo. In short, their proposed revisions would call for creation of a County Regional Justice Facilities Council in each county covered by the Act. And the council would provide information and make recommendations regarding justice facilities to the county that it serves and the facilities division of the Judicial Council. And then the court also suggested various specific revisions about the composition of the entity that would be created and its powers and duties and so forth. As far as questions for the commission to decide today, the commission needs to figure out what to do in light of the input it received on the discussion draft. It probably would be helpful to break the decision-making into 2 steps, with the first question being what to do with regard to every county affected by the acts except Humboldt County, and then the second question being what to do in Humboldt County. So if that's acceptable, then the first question, what to do in counties other than Humboldt County. So that would be Los Angeles, Orange County, Riverside County, San Bernardino County, San Joaquin County, Stanislaus County, and Ventura County. For these counties, it seems likely that the legislation we are discussing here, the Regional Justice Facilities Acts, could be repealed or at least made inapplicable to those counties without causing any concern. The commission could test this by issuing a tentative recommendation to that effect. And so I think the first question for the commission to decide is, would it like to do that, to prepare a tentative recommendation proposing to either repeal or make the acts inapplicable to those particular counties.
Barbara Lee asks perhaps a dumb question, but the fact that the budget is being radically changed and that there's all sorts of cutbacks, would it be helpful to extend the comment period before making these decisions, or are we okay with just proceeding today?
Well, I think that if the next step, since this was a discussion draft rather than a tentative recommendation, I think that the commission could go ahead and proceed to a tentative recommendation, and then there's still another opportunity for people to comment. And I would point out that I did make a lot of special efforts to contact the courts and counties that are affected by this particular discussion draft already. We sent out the original draft. We sent out a reminder about it. Later on, I sent out the memo that discusses the comments, and also, sent individualized letters to the courts and counties about that. So I feel like we've, made more effort to get input on this than usual. And if we proceed to a tentative recommendation now, there'll still be even another shot for people to weigh in on it. So I think we really have given quite a long and ample period for people to weigh in.
Commissioners, any other thoughts? Okay, do I hear a motion to repeal the Regional Justice Facilities Act, or at least make it inapplicable to all the counties listed except for Humboldt? Is that the proper motion there, Barbara?
Yes, I think so.
Moved.
I'll make the motion.
Was that second? I'm sorry, I didn't hear.
I was
Some-
either making the motion, either way.
Okay, so you'll be the second then, because Commissioner Simpson already moved. All right, any discussion?
Perfect.
Any discussion? No, and no audience members want to be heard. So let's proceed to the roll call vote. All those in favor say aye and raise your hand. Aye.
Nay.
Aye.
Aye.
Anyone opposed, raise your hand now and say nay. Seeing none, any abstentions? Okay, the motion is carried. Thank you. Now we turn to the same motion, but limited to Humboldt, correct, Barbara?
Well, right. The next issue is, what are you going to do about Humboldt County? And as discussed in the memo, the staff sees really three main options for how to proceed with respect to Humboldt County. The first option would be to prepare a tentative recommendation that would try to effectuate the concept suggested by Humboldt County Superior Court. So revising the Multi-County Act to call for creation of a county regional justice facilities council, and then enumerate the various powers and duties and composition of the council, and conform the act to reflect the trial court restructuring changes that happened at the turn of the century. So that would be one possibility. I think that creates a danger of taking the commission rather far afield from its duty to implement trial court restructuring. A second possibility would be to prepare a tentative recommendation that simply proposes to repeal the act applicable to Humboldt County. So that would be essentially the same treatment as the other counties that we already discussed. That's certainly more clearly within the commission's authority than the first option I mentioned. But the court in Humboldt County did put quite a bit of effort into providing comments to the commission, and seems troubled by the existing situation there. It might be helpful to do something to try and resolve their concern in some manner, if only to point things in sort of the right direction. And so a possible middle ground would be to prepare a tentative recommendation that proposes to repeal the act with regard to Humboldt County, but also draws the legislature's attention to the court and to the concerns raised by Humboldt County Superior Court, and perhaps provides some degree of insight into those concerns if the commission learns anything further about those concerns, or at least can point to what the court has already said about it. So the staff leans towards that approach. I guess the next thing would be to ask if there's anyone who would like to provide some comments on the options from the audience. And if not, then the commission should resolve which of those options to pursue, or
Commissioner Carrillo.
some other idea.
Yeah, I had two thoughts. One is that it seems a little odd to have a statutory scheme that applies to 57 out of the state's 58 counties. And then the second issue is that if we're going to be basically like putting this on a plate for the legislature and saying, here's a problem, you guys really need to sort this out, it strikes me that that's kind of our job to at least take an initial cut at sorting out the issues and bringing them a proposed solution rather than just a problem.
I'm sorry, I don't understand about the 57 out of the 58.
I thought the proposal was to propose excluding Humboldt from this statutory scheme.
No, there are 3 acts currently in place. One applies solely to Orange County.
Right.
That one you've decided to repeal. One applies solely to San Joaquin County. That one you've also decided to propose to repeal. The third one applies to, I believe it's either 7 or 8 different counties, one of which is now Humboldt. With regard to that one, the commission just decided that except for every county besides Humboldt, you want to propose to repeal that, or at least revise it so that it would only apply to Humboldt. So what you're talking about here is either you'd have a statute that only applies to Humboldt County, or you'd have the entire thing repealed, all
So
3 acts.
I think that's what I would lean towards. When I was looking at this, I thought that the arguments made by Humboldt County were persuasive, not just as to Humboldt County, but as to all the other counties that it applied to.
Well, I think they were proposing to do it for all the other counties and this particular act would, it's like I say, it's 7 or 8 counties, including Humboldt, but that's not what the staff was suggesting. The staff was suggesting do it only in Humboldt, whatever.
Commissioner Boyer-Vine.
Yeah.
Commissioner
I was going to say, I
Boyer-Vine.
respectfully disagree, and I will cede the remainder of my time.
I actually would not do what Humboldt wants to do, Barbara. I think Humboldt, if they have an issue, must have a lobbyist or an access to the legislature or the judicial council to talk this through, and I would just repeal the statute.
I would tend to agree with Commissioner Boyer-Vine on that. Do we have any audience members? Seeing none. So Barbara, you need a motion. Well, any other input from commissioners? If not, let's proceed with a motion along how Commissioner Boyer-Vine just outlined.
I'll make that motion.
So this would be a tentative recommendation to repeal all 3 acts.
Right.
Repeal or make inapplicable. That's what's
Right.
Well, no, as long as you're going to apply it to all of the counties, the same treatment, then it's simply a tentative recommendation that proposes to repeal all 3 acts.
Got it.
Rick, did you have something?
No, second
Okay.
motion.
Okay, so the motion is to repeal with regard to Humboldt County. So any further discussion? Seeing none, all those in favor, raise your hand and say aye. Aye.
Aye.
Anyone opposed, say nay. Seeing none, any abstentions? There are none. Thank you, Barbara.
Okay.
Now we're moving to the next agenda item, statutes made obsolete by trial court restructuring with regard to court reporter compensation, Memorandum 2020-15.
Okay, well, this is my memo too. This memo is purely informational. It provides the background on the history of the court reporter compensation statutes, how the commission dealt with them in the early phases of trial court restructuring, which was basically tried very hard to figure out how to address them, but it wasn't possible to reach any consensus. And we've had this on our to-do list for many years now. We've revisited it once a number of years ago. We've been looking for a good opportunity to deal with these statutes, and there just has never seemed to be one. And it's seemed time to at least raise the issue for discussion again, rather than having the commission make decisions on this memo. At this point, it seemed better to sort of introduce the study, provide the background, and then come back with a memo for the next meeting that discusses the pros and cons of some different options for the commission with regard to these court reporter compensation statutes. In the interim, the staff has already been trying to drum up stakeholder awareness of the fact that the commission is taking another look at these statutes. And we have already some input where we like to, be able to give people an opportunity to weigh in. And so that's the reason that it's segmented in discussion. But there's really nothing here for the commission to decide today. If there are any people in the audience that would like to comment, it'd be great to give them an opportunity. And otherwise, we'll just work on the next memo for the next meeting.
Okay, I see no comments anywhere, correct? All right, does that conclude that item, Barbara?
Yes.
Very good. Moving on to stock cooperatives and uniform TOD Security Registration Act, Memorandum 2020-16. Any audience members who wish to be heard, go ahead and raise your hand. I see one person, Mr. Anderson, will get to you. If you want to go ahead and introduce this, is this yours, Steve?
Yes, it is. There was another attorney who said he might be joining the call, but I don't know how it works. I don't know if you're seeing only phone numbers or are you seeing names?
I see either, depending on what method they're using to chime in. And do you know the name of this individual?
Jeff Beaumont.
He's not on my list whatsoever.
No problem. Just wanted to.
Is it important enough for us to push this matter later to the later on the agenda?
About it, and he said he expected that he would probably chime in, but he's very busy, so who knows?
Okay, why don't you go ahead and then we'll hear from Mr. Anderson.
Sure, that's great. Okay, so this is Memorandum 2020-16, and it continues a discussion of whether a uniform act that was promulgated by the Uniform Law Commission in 1989, an act entitled the Uniform TOD Security Registration Act, can be adapted by the Commission to implement a non-probate transfer on death of an owner's real property interest in a stock cooperative. That's a residential development in which a corporation owns the entire development and individual owners purchase a share of stock and then enter into an occupancy agreement in order to reside in the development. This study originated out of another study, the Commission's study of RTOD deeds. Part of that was a directive from the legislature to advise whether the RTOD deed statute, which provides for non-probate transfers on death of other real property interests, should be expanded to apply to stock co-ops. In 2018, the Commission recommended against that expansion because the RTOD statute relies on recordation of a deed, and an owner's interest in the stock co-op is not evidenced or conveyed by a deed, even though it is a real property interest. So the Commission decided to commence this study instead to see whether the Uniform Act might be adapted to provide co-op owners with that non-probate transfer on death. To start its work in the study, because the Uniform Act has been enacted in 48 states, plus the District of Columbia, and because many of those states also have stock co-ops, the staff looked into whether any of those other jurisdictions had attempted this kind of adaptation of the Uniform Act, and if so, how it was working. However, as best as the staff has been able to determine, no other jurisdiction has made use of the Uniform Act for this purpose, or apparently attempted to do so. The staff engaged in legal research looking for evidence of this use, also talked to attorneys who represent co-ops, including in New York, where they have many co-ops, and associations representing co-ops. No one had heard of the act being adapted in this manner. But as indicated in the memo, we did learn that through an interesting combination of circumstances that includes the Commission, the Uniform Law Commission that recommended the Uniform Act, and I'll start referring to them as the ULC to avoid confusion, had itself at one point considered this issue back in 2007. The Law Revision Commission had recently recommended to the legislature the enactment of an RTOD deed statute. This was back in 2006. And although that recommendation suggested that it might apply to stock cooperatives, a stakeholder had contacted the commission shortly after, while the recommendation was pending in the legislature, and expressed concern about whether the recommended statute could really effectively be used by owners of co-ops, in part because the recommendation required recordation of a deed. The commission thought the issue was too complicated to address while the recommendation was pending in the legislature, but the stakeholders' email found its way to the ULC, and specifically to the assigned reporter for a committee of the ULC that was at that time working on drafting a uniform RTOD deed statute. The reporter prepared a memo to that committee, including the email of the stakeholder, and asked the ULC committee if it wanted to expand the scope of the statute it was working on to apply to the interests of stock co-op owners. The reporter also suggested that if the committee wanted to pursue doing so, it might consider loosely modeling a statute on the Uniform Act that the commission is now considering in order to achieve its goal here. There were no minutes available from that meeting of that committee, but the staff found nothing in any ULC material that appeared to indicate that either that committee or any other part of the ULC had pursued this possibility of adapting or drafting a statute that would apply to co-op real property interests. The staff contacted the reporter, who didn't remember the meeting but found notes that he had taken indicating that the committee had decided that the RTOD deed statute it was working on should be limited to real property interests transferred by deed and not to other ownership interests not fitting this description, such as an interest in a co-op. So, with that background, the staff began reviewing the provisions of the Uniform Act to evaluate what adaptation might be required in order that it could be used to facilitate a non-probate transfer on death of a stock co-op owner's interest. This memorandum discusses only one of those provisions because the staff felt that the commission's view about this provision could possibly be determinative of how the rest of the study would proceed. Interestingly, as indicated in the exhibit, this same provision that I'll discuss was also identified by the ULC reporter when he was presenting the idea of adaptation or modeling of the Uniform Act to accomplish this goal. So this provision is section 5508, Probate Code section 5508, and it's set out at the bottom of page 5 and top of page 6 of the memo. Before discussing that provision, it's important to again refresh on how a non-probate transfer of a security is implemented under this Uniform Act. Unlike the RTOD deed statute that allows an owner to largely act unilaterally in effecting a non-probate transfer, the Uniform Act provides that the non-probate transfer of a security must be implemented by the entity issuing the security to the owner. And they do so by registering the security in what's called beneficiary form. And section 5508, this is in subdivision A, provides that whether or not the issuer wants to offer this registration is optional on the part of the issuer. The section also provides, because if the issuer agrees to register the security in this form, they're obligated to comply with various formalities regarding implementation and execution of the transfer. The section offers the issuer some fairly substantial but not ironclad protection against liability if they mess it up. So, taken together, this section raises the question of whether, at least for some co-ops, if not many, offering the registration, something that they're not exactly set up to do right now, might not be too much of a burden or expose them to too great a risk of liability such that many would just choose not to do it. And that would thwart the commission being able to achieve its objective in the study. Because of the burden that is imposed on the co-ops and the risk liability the staff certainly does not recommend making this issuance mandatory. In other words, that would theoretically be a way to address the issue of no co-ops or few co-ops offering registration, but the staff feels that would be worse. Because much better, just like for the commercial brokers that the Uniform Act is probably designed to apply to, there can be substantial reasons why an entity might not want to do it. In fact, with the Uniform Act, the ULC devoted a substantial amount of time talking to commercial stockbrokers to find out what would work best for them. And that's the reason that the provision was made optional, because of what was communicated to the ULC. So, the question basically then for the commission is whether, as section 550 now reads, making this voluntary on the part of the security, which would be, in this case, the board of the co-op when somebody is trying to purchase an interest in the co-op, whether the burden on the co-op, along with the risk of liability that is not shielded by the protection provision in 5508, would sufficiently deter so many co-ops from doing this that the commission would not, the recommendation would not result in any real reform. In other words, we go through all the rest of the provisions and we adapt it so that it works, but we keep this exactly the same, and then nobody uses it, or a few people use it. One way the commission could address this problem is to provide stronger liability protection. The liability protection right now it's fairly standard, but it's not great. There are holes in it. It requires the co-op to demonstrate good cause for doing what they did if they made a mistake. That is not as good protection as, for example, appears to be provided to banks when they allow an account holder to designate a beneficiary who's going to receive the content of their account upon their death. That basically the liability, there's no liability unless there's been an order from a court that the bank has received. So, or the commission, another possibility, the commission, if it feels that there's no way to resolve this situation, it's possible that the staff could explore whether there's some other ways, independent of the act, that would allow for this transfer of co-op interests. But essentially, this is, that's the question for the commission right here, and your thoughts are very much appreciated, and it would be obviously very helpful to know which way the commission is leaning at this point.
Steve, correct me if I'm wrong, but the commission's already decided to exclude the transfer of these stock things from the TOD transfer. So this is a way to kind of reverse that in part. Is that right?
Yes, it's a way to sort of meant to be kind of a substitute or an alternate that does not require recordation of a deed, because that was the primary obstacle.
So if we stick to the decision we made a couple of months ago, we wouldn't even need to go into the nuances of how to register and how voluntary that process would be.
Well, so we're the commission decided to work on trying to make this Uniform Act work to facilitate this non-probate transfer of stock co-op's interest. So that's the assignment, and that's what we're working on. And the question is this provision, what modification might need to be made to this provision in order for this adaptation to work? There's a
Commissioner Boivin.
So I just wanted to add a little bit of more from the Uniform Law Commission, because when I saw this memo, I reached out to Ben Orzeski, who's their ledge counsel and had worked on some of this with the TOD. One thing he points out, which leads to the idea that you should keep it voluntary, I think, and Brian Wayne, if you disagree with me, is that a TOD transfer of one's interest in a real estate cooperative can be problematic because many of the cooperatives have restrictions on who can hold an interest. So for example, a cooperative may limit it to residents who are age 55 and older, or there may be some restrictions developed under federal housing regulations, and the current owner may have met those, but the person you're going to transfer it to has not. So leaving it in the voluntary nature allows, I guess, the cooperative who has very limited eligibility requirements or provisions for the cooperative to not allow the TOD. So just a point I wanted to make.
Well, you asked for my thoughts. I think the staff agrees that it should be remain voluntary if it's made applicable to stock co-ops. You know, some stock co-ops may feel like they just don't have the expertise and resources to do a good enough job on such an important thing and may not want the burden, like Steve said. So keeping it voluntary like it currently is for stockbrokers makes sense. The issue you raise about use restrictions on the deed, we're planning to talk about in a future memo because I think we can finesse that, but it is another point on which co-op boards might feel unease. If they've got a particularly strict or unusual restriction and they're not satisfied that the statute protects them enough, then fine, you shouldn't force them into participating. I agree with that. It might make sense to hear from Mr. Anderson, because I think Steve has presented most of the information in the memo, and it might be worthwhile hearing what TexCom thinks about this.
Yeah, I'd like to call in Mr. Anderson, but let me give a heads up to Nate Sterling, because the memo specifically says we're going to reach out to him for input, and he's on this call. So after Mr. Anderson, Nate, if you're prepared to talk on this, we'd appreciate that. Mr. Anderson, go ahead.
Thank you. Good afternoon, Steve. I actually don't have much to say. TexCom has a working group that will be looking at this and chiming in if we feel we have anything helpful to say. But at this point, we don't really have anything helpful to say one way or the other. So I'll just leave it at that.
Okay, Mr. Sterling, I'm sorry to put you on the spot, but the memo called you out as saying that you're a person who might have some insight into this issue. So do you have any thoughts, Mr. Sterling?
I will enable him to speak if he wants to. He would need to unmute his mic. There we go.
Okay. Well, hello, everyone.
Hi, Ned.
Hello.
I've just been sitting in on the meeting just because I noticed the Zoom meeting made it very convenient, and I haven't been to a commission meeting in a while. And I was somewhat surprised to see that a lot of the material that I used to work on the staff of the commission a dozen years ago is still on your agenda. So these things never go away. I did take a quick look at Steve's memo on these stock cooperatives, and I do not have a specific recollection of our decision-making or thought process as we went through this, but at least my guess is that when this came to the Uniform Law Commission and it was working on its transfer on death deed statute, I think we wanted to keep a fairly narrow focus on traditional real property deeds and not to complicate it. You know, this was in an era we were still going through the non-probate revolution, and there was a lot of resistance to many of these non-probate devices. And this would be, and particularly the transfer on death deed, as you're seeing now, there's still resistance, both from, I believe, from the probate bar and from the title industry and all that. So in order to keep it focused narrow and direct, I think we probably just decided not to deal with the stock cooperatives. As far as the application of the security registration provisions, to me, we did not, when the commission proposed that that enactment, we did not really do an in-depth analysis of that statute and how it would apply more broadly. But you know, listening to the discussion, it certainly makes sense to me that a voluntary system would be appropriate. I think, you know, it's hard to believe that it could not be easily implemented by a lot of these stock cooperatives if they wanted to. So this would provide a useful tool, but I agree that forcing it doesn't make a lot of sense. What you would have if you did allow a registration that was that violated some of the use restrictions of the cooperative, the board would be put in a bind as to how to deal with it. That probably they would dishonor the transfer, and then you'd end up in court and you have a judge having to determine it. So the whole point of these non-probate transfers is to stay out of court and allow things to go smoothly. So I would agree with that approach, of making it voluntary.
Okay, Steve and Brian, it seems like we seem to have some consensus on this voluntary approach, but Lay raised the question again, isn't another approach to just not allow stock cooperatives to have this option?
Just not do this?
Yeah.
Yeah, that's certainly a possibility. The issue is that when we were given the assignment from the legislature to do a follow-up study on the RTOD deed, they specifically directed us to look at the appropriateness of applying RTOD deed law to stock co-ops. And I'm pretty sure that was because Mr. Gatto, who was the author of the follow-up study bill, got input from constituents that they wanted to be able to do that. The letter that Steve found from Bob Shepard is another person who lives in a co-op who wants to be able to do it. I've gotten email probably from 1 or 2 people who were upset when they learned that there was an argument that the RTOD deed statute didn't apply to stock co-ops, and they wanted to be able to do it. So the legislature asked us to look at it. We concluded it was a poor fit for a statute that depends on recordation of a deed. But we offered as an alternative looking at whether this securities TOD statute could be adapted to do it. And we, as you pointed out, we just said that 2-3 months ago in our final report to the legislature on RTOD deeds, that we would look at whether or not this is workable. So it's conceivable that it might not be workable, but I would counsel against prematurely pulling the plug on the inquiry because we just said that we were going to do it.
Okay. So then I sense that the motion needs to be to proceed to give you authorization to explore this voluntary option because we seem to have a broad consensus that voluntary is more realistic in this situation.
Yeah, that's the first of 2 issues presented for decision in the memo.
Right. The second.
Well, let's see what they think about the first. Sorry to cut you off.
Okay, anyone from the audience or any commissioners want to comment on the concept of voting on proceeding with drafting something that makes the registration voluntary? Okay, no comments. Do I hear a motion on that?
So moved.
Second.
Okay, moved and seconded. Any further discussion? Seeing none, all those in favor of drafting language to make registration voluntary, and of course with the underlying presumption that this helps make stock interests transferable in this manner, everybody say aye and raise your hand. Aye?
Aye.
Aye.
Anyone say nay? Seeing none, any abstentions? I see none. Okay, Steve, what's the second issue?
So the second issue is whether the liability protection in the section that you're looking at should be strengthened in some way, whether it is right now allows still for too much risk of liability on the part of the co-op, such that it would dissuade most co-ops from offering this. This is discussed in the memo. It could be stronger. We could make the protection stronger. We could look for other examples. As I mentioned, the protection offered financial institutions who allow TOD transfers of bank account balances looks to be a little stronger. There may be others that we could present. It's sort of finding a sweet spot because, of course, if you provide too much liability protection, that works against the interests of the stock co-op owners, who, of course, is who the board is representing. So, if you provided too much protection, then anyone who used the registration, any owner who used the registration might not want to do it because there would be no protection for something that was messed up significantly. So that's really the question, is asking the commission whether it wants to make some change to the liability protection that's currently in section 5508.
And I could offer a little background on this issue more generally. I'm sure Nat could too. It's fairly common in the law to provide this kind of limitation on liability when third-party property holders are directed to transfer property according to an instrument. If they act in good faith, if they don't have actual notice of a contrary claim, there's usually some kind of statutory protection in place. And that's true for this Uniform Act. It's true too for the multiple party accounts law. That's what Steve was talking about. So if you have a bank and a client with a pay on death bank account, and the named beneficiary comes in with a death certificate and presents it to the bank, and the bank pays out to the named beneficiary, there's a statute that says they're not liable if it turns out that that was not proper, you know, and maybe it was the product of undue influence and somebody successfully contests it. That person's relief comes from the beneficiary, not from the bank. And so that's what this is a provision of that type. It's pretty good protection as is. You know, it protects you if you act in good faith and without written notice of a contrary claim, and you abide by the requirements of the statute. The strengthening that Steve points out in the multiple party accounts law is kind of subtle. It doesn't have a good faith requirement. And I think more importantly, instead of saying that you have received written notice of a contrary claim, it says if you were served with a court order prohibiting the transfer. So you've got a lot more latitude if you're a bank. You could actually get a letter from somebody who says, hey, don't do this. I'm about to go to court to do something about it. You could still pay out and have your liability limited because you haven't yet received the service of a court order. So it's possible, if you're worried about stock co-ops, which are, you know, like all CIDs, they're sometimes run by amateurs, and their exposure is pretty large. It's a piece of real property. If you're worried about them making a mistake and being on the hook for it, and that perhaps deterring co-ops from using the mechanism at all, then maybe one way of addressing it would be to strengthen the liability limitation. And that's what the memo asks about.
What I find interesting about this discussion is that it's partly based on supposition. We're saying that we're going to discourage people unless we have stronger liability protections. But do we have stakeholders telling us that? I mean, are there special interest groups or somebody out there actually telling us they want greater limitation on liability?
Well,
Steve?
We haven't received any significant comment from stakeholders.
So my inclination is, you know, sort of the Hippocratic Oath, let's do no harm. Why would we want to limit liability if no one's asking for that, based on our supposition that if we don't limit liability, that people would be scared to use these provisions? If Brian is saying that these cooperatives are full of non-professionals or for lack of a better word, amateurs, well, then they should be worried about using these provisions willy-nilly and should have liability looming over their heads. So I'm just a little puzzled as to why we want to limit liability based on our belief that would discourage people from using this process, as opposed to actually a stakeholder telling us this is an actual need.
Victor, it also could mean that we're clarifying, because I'm interested in adding the good faith component to it. So it's not so much as limiting liability, it imposes a duty for the parties to act in good faith.
Well, just to be clear, the existing Security Registration Act that we're examining has a good faith requirement. It's the other statute that we're looking to as an alternative approach that does not. So if you did what Victor is suggesting and stuck with the terms of the Security TOD Registration Act, it would require good faith in order to have liability limitation.
Right.
I think that covers it.
Yeah, and that's why I'm saying that. I don't see the reason for us to limit liability, because that would encourage more people who don't know what they're doing to try to do this, and they'll just create more havoc. I think you should have liability looming over your head so that you seriously consider whether or not you want to do this, and it'll sort of raise the level of professionalism with regards to these decisions. We don't want to be enacting decisions that will encourage people to take a Wild West approach to these sort of things. That's my thought. Just a thought. Any comments, Mr. Anderson, anything else? Or you raise your hand if you have anything else, or no one else? Okay. Any other commissioners' thoughts? Okay, I would like to propose a motion to not explore strengthening liability limitations. Would that be the proper way to phrase it, Steve?
Well, sure. I think the direction is to, that basically the provision as it's written,
yeah,
it seems pretty much okay. It's voluntary, and the commission wants it to stay voluntary, and the protection is based on good faith, and the commission wants there to be a good faith requirement. So this was offered because the staff thought there was a possibility the commission might want to go a different way, and if so, that would affect what we did. But if the commission is fine, at least for now, with the way this section 5508 reads, then we're on to looking at the other provisions.
Okay, am I also right that you don't need a vote now, Steve, because we're saying status quo, so you don't need a vote to veer off of status quo?
That's correct.
It's also not a hard decision point. It's just guidance to staff, and we'll just carry it forward.
Any objections, Commissioner? So, the tentative sort of direction is we're going to stay with the status quo and not offer additional liability limitations. Okay? Seeing no real objections, I think we're done with that item. Is that right?
Yes, that's right.
Okay, very good. Does anyone want a 5-minute break right now, or should we just plow forward?
Yes.
Okay, let's reconvene at 2 o'clock.
All right, I'm going to suspend the recording and put on our intermission sign. It's nice to talk to you, Nat.
Yeah.
First presentation was great. No, seriously. Period. You didn't seem awkward at all. Period. Good luck on the next one! Exclamation point. We'll be drinking margaritas.
Welcome back, everyone. It's exactly 2 o'clock. Let's move on to our next item, non-probate transfers, creditor claims, and family protection. Any audience members who wish to be heard, please raise your hand.
Good afternoon, Commissioners. So Memorandum 2020-17. This memorandum continues a study that the Commission had undertaken on non-probate transfers. The study was based on a background report that was actually prepared by Mr. Sterling, so I'm hoping that he'll have an opportunity to have some comments. The study has been inactive a bit, so I was going to take a step back and give kind of a big picture look at what this study is about and why we're doing it. But first, I do want to take a moment to reassure the Commissioners, there's a lot of detailed items that are put up for decision points in this memo. We actually don't need to address all of those items today. Mostly this memo was an effort to try to identify some of the complications that we might run into as we proceeded with a reform to apply family protections to non-probate transfers. And now I'll get into what that really means. So traditionally, a decedent's property would pass through something called probate administration. So the decedent would either have a will or not have made property arrangements, and the property would go through a process that's overseen by the courts where the decedent's property is all gathered, the creditors of the decedent are paid, the family of the decedent can seek certain protections, and then the property is distributed either according to the decedent's will or a statutorily described heirship scheme called intestacy. So the problem with probate is that it takes quite a bit of time. As the memo notes, 9 months is typical, and they can go much, much longer than that. And the cost of probate can consume quite a bit of an estate. And the estimate offered in the memo was 5 to 6% of a modest estate. So there was mention of the non-probate revolution. In the past, there was an effort to start giving people options to pass property outside of probate. So these instruments started growing and becoming available so that people could say who should receive their property on death without those people having to wait for the process of probate to be completed or having to pay the costs associated with probate. So some of the non-probate instruments include, one of the big ones is trusts, pay on death bank accounts, security registrations like we just talked about. But all those things are pretty simple where the beneficiary, well, aside from trust, all of those non-probate transfers are pretty simple. The beneficiary can simply go and collect the property after providing some proof of the decedent's death and their identity. Trusts are, of course, a bit more complicated. But the reason why we're worried about these non-probate transfers is the fact that they pass outside of probate means that some of the functions of probate are not happening anymore. So the creditors are not necessarily getting paid. The family doesn't necessarily have an avenue to seek protections when the decedent's plan didn't provide for the family. So previously the Commission was proceeding with a reform that would apply family protections to non-probate transfers and subject non-probate transfers to creditor claims by putting those non-probate transfers back into a probate. The Commission, based on feedback that we received, decided to take a different path, but directed the staff to look at the application of family protections to probate or to non-probate transfers. So the family protections that this memo addresses, there are 4. 2 of them are only really applied during the course of a probate proceeding. So for a certain period of time, the family is allowed to hold on to certain property of the decedent, certain necessities, and they can just keep those until a certain stage of the probate proceeding, and the court can extend that for good cause. Another one is the family can get support payments, the family allowance. So during the course of the probate proceeding, while that's going on, the property is being sort of held in that proceeding, the family can get periodic payments to make sure that they have enough money for their maintenance. There are 2 family protections that apply beyond probate, which permanently transfer certain property to the family, contrary to the decedent's intent to give it to somebody else potentially. There's the exempt property set aside, and that takes property of the decedent that would be exempt from the enforcement of money judgments and gives it to the family, regardless of who the decedent wanted to give it to. It also seems to provide some creditor protection. And the last one is the probate homestead. Probate homestead's a little bit different. It gives the surviving family members a permanent use right in a particular piece of property. So probably typically it would be, you know, a single family home that the decedent owned just as their own property. If the decedent was living there with the surviving spouse, but the decedent gave that property to someone else, the surviving spouse could petition for a probate homestead that would allow them to remain in the property for a potentially very long period of time, extending up until the surviving spouse passes away. So those are the family protections that the memo talks about. The main question for the commission today is whether or not you want to move forward with looking into the application of these family protections to assets that are passing outside of probate. So I'm going to focus on the probate homestead for just a minute to kind of give a sense of what that might look like. Where the property is in probate, the court can impose this protection. So if the decedent had a home, and the decedent intended to give that to a sibling, the family could petition and say, hey, you know, we need to live in that home. Court, please grant us a probate homestead. The court could say, yes, you do need that home. I'm going to impose a probate homestead on that property. And what that means is the sibling who was intended to receive the property gets title to the property, but it's subject to that use right. So essentially they get property, but they have to wait for the use right to expire before they can really access that property. It's a pretty significant shift in the decedent's estate plan, but it's the existing policy in probate. Now, if the decedent instead put the house in an RTOD deed to give to a sibling, the spouse would have no way to request a probate homestead over that property because the property passes outside of probate. Now, it's not clear why that property should be treated differently. There's not a strong policy reason that California would want to impose probate homesteads only if the property passes through probate. But it would be a significant change to how non-probate transfers work to impose these probate family protections on the non-probate transfers. And I think that, I mean, that's the big question for the commission is, do you want to continue exploring doing this? And I expect that Mr. Anderson from TexCom might have some input and Mr. Sterling as well.
May I recognize Mr. Anderson? You want to unmute there, Mr. Anderson, or Brian, can we unmute him?
There, I unmuted. Can you hear me okay?
Yes.
All right. Well, thank you for letting me speak. So TexCom we have not looked at this memo at all so far. So I'm not speaking on behalf of that body. I'm just offering thoughts as an estate planning attorney who's done this for a while. And, you know, so you can take them for what they're worth. In my experience, both through probates, I've never personally been involved in a state where these family protections have been involved. So I think that that's not to say that they are not important or that they are not used in certain circumstances, but I think because, you know, California is a community property state, especially where there's a surviving spouse, I've not seen these come into play very often. Switching over to non-probate transfers, which is how we try to conduct most of our estates, which we primarily do through trusts. Again, I haven't seen a need for this type of for these type of protections. I haven't seen much literature or discussion in the probate bar materials talking about the issue, but again, that's just one person's perspective, and that's not to say there's not there's not a need in certain circumstances for something like this. But anyway, I just wanted to share that's basically what I had to say at this point. You know, again, TexCom hasn't looked at the issue yet, so I'm not speaking on behalf of that body, but of course, we would be happy to provide technical comments at the appropriate time as this moves forward.
Kirsten, can I ask a question about what I am reading as a potential discrepancy between page 10 and page 11 of your memo? On page 11 in the bold, you say that the staff recommends that we not make it applicable to non-probate transfers because that's the same approach as the earlier approach. On the earlier approach on page 10, you ask us whether to make it applicable as opposed to recommending that it not be applicable. So I was confused by that difference.
Yeah, so those are two different protections. The first one is a protection that allows the family to just retain possession of certain property for a temporary period of time. And that one, we're just posing a question as to whether or not the commission is interested in allowing, say, someone who got, or the situation that I described previously, where the decedent transferred a house that they owned themselves by Rtodd deed to someone other than the surviving spouse who was living in the home, should the surviving spouse, say, have a right to stay in the home for a certain temporary period of time. The second one, which is the recommendation that we actually exclude on page 11, is what's called the family allowance, those periodic support payments. And that was based on previous decisions that the commission has made in other probate-related studies, that the family allowance is really just a cost of doing probate, and the fact that probate kind of locks up the property for that time period, the family might need those periodic payments, but that would not necessarily be the case in the absence of a probate. Okay.
My thoughts, just from listening to this discussion, is that none of these family protections are necessary, because if you look at from the 10,000-foot view angle, the whole point of a non-probate transfer is because the decedent has, in some form, whether or not it's a transfer on death deed or a will or something else, has expressed where he wants the property to go. And the reason you have these protections in probate is because the decedent hadn't expressed any intentions and maybe wanted to protect his family, but just died, unfortunately, before he had an opportunity to memorialize that. So my initial inclination seems to be more acceptable, and since Mr. Anderson himself says he's never seen these family protections invoked in probate or in non-probate transfers. Any thoughts on that? Commissioner Borivine.
Yeah, I don't really know this area very well, and this study has eluded my attention a lot, but I'm trying to figure that through. I thought there was a concern that in these non-probate transfers, and maybe Nat can answer this, that I mean, you're expressing that they know what they want to do as to the property, but maybe they're not always as sophisticated as they should be about the ramifications of what they're doing, and not using a lawyer. And that's the point of these non-probate transfers. These kind of things is to get out of using a lawyer. Sometimes maybe not. Maybe they are using lawyers and I'm wrong. So I just don't know enough. I'm just wondering about your assumption that they really know what they're doing in these non-probate transfers. Commissioner King.
Any thoughts, Brian?
Yeah, the one point there where I would refine what you said, Victor, is that the existing policy extends to situations where the decedent knew what they were doing and intended to disinherit their surviving spouse or minor children. And if the family protections can be imposed in that situation and they contravene the decedent's intentions, it's a policy choice that under the existing protections, we're going to provide for the maintenance of the surviving family members, even if the decedent didn't want to.
That's awfully paternalistic to me. I mean, I would think.
Correct me if I'm wrong on that, but my sense is it's not just about omissions, inadvertent omissions. It can also be about they just blew the money elsewhere, gave it away to other people. They just didn't care about their survivors.
Which was their right, which is my point. The whole point, as I see it, for having these non-probate transfers is to avoid the probate and all the craziness of all the court time and court expenses. So now we're proposing to do something that complicates things and to assume that the family needed to be taken care of and assume that the decedent wouldn't have a problem with that when he really wanted to give the property to his sister because he really didn't like his wife or his children. So I in general, I don't want to sound mean-spirited, but I don't really see a need for these family protections, all four of them. Any other commissioners? And please argue to the contrary. I'm not trying to be Scrooge here.
I mean, I would just add very briefly that, you know, Kristen and I talked about how to present this topic because a lot of it is in the weeds. And, you know, it was the idea that by starting by explaining exactly what the probate homestead does, you know, it takes a house that you intended to give to your sibling and instead burdens it with a lifetime use right for your surviving spouse that you never intended to create. We thought by showing that that's the existing policy, you could have a very 10,000-foot view discussion of whether to extend that policy before we get into the details of doing it, how it would be done. So I'll shut up now.
Well, I guess my point, again, from the 10,000 foot view is we were trying to create a system where there would be not much complication to transferring property. And this just adds another complication. And it presupposes the decedent really cared about the minor children or the wife to this extent. And again, that's a presumption that I don't think we should make. Any contrary thoughts? If people believe that, do we want a motion or do we not want to take any formal action now, Brian, so that we could percolate this further?
I just saw one of the commissioners unmute, so I'd like to hear what she has to say.
Well, I don't know. I mean, again, this topic just, I don't engage in it at a level I probably should, but I'm a little bit concerned with what Commissioner King's saying, just from a policy perspective. So I guess my inclination is maybe to follow his second path of letting it percolate a little bit more, but that's just my feeling, because I'm uncomfortable making that 10,000-foot assumption.
Don't get me wrong, I'm not trying to drive a stake into the heart of this. I have no burning desire to end this discussion today. I'm just concerned that we've for many months have been saying we want to create a burdensome free way to transfer property before death. And now we're just adding burdens. That's my concern. But I have no great desire to kill this today. Commissioner McAllister.
I think possibly it would be helpful to see if we could get TexCom or some other stakeholders to comment on this. I know Mr. Anderson said he has not seen this particular issue come up, but it would be helpful to know. I mean, maybe this is just a moot point. You know, the thing about non-probate transfers is a lot of times they're very piecemeal. And if you're trying to cobble together a policy or a remedy that is pulling in assets that can be of pretty minuscule value overall versus, let's say, a house, which would be the big value, right? Or possibly a retirement fund. It's pretty messy, and I think that, not that that should be a discouragement, but personally, I would really like to throw some hooks out there and say, all right, this is an issue that we're trying to grapple with. Maybe you can give us some more practicalities as to whether this is something that would be happening. Can we give some more information about if it's happening, how it happens? You know, I think that would be my inclination, is to just try to get a little better sense of exactly the ramifications and if it's necessary or if it's just something that's once every 10,000, 1 million cases or so. I mean, that's just how I would approach it personally.
Commissioner Simpson.
I will confess I know even less about this than Diane does. But it sounds to me like just sort of fundamentally, this is a trade-off between sort of simplicity and equity. And honestly, I tend to go with equity more than simplicity in policy choices, but my inclination is finding out a little more about this as to whether in practical applications this really could be an important piece of the non-probate process. I'd like to find out a little more about that. So
Okay, can we unmute Mr. Anderson? Are you okay with the thought of us putting this over to the next meeting or maybe a later meeting? And will you be able to provide some input from TexCom, you think?
Yes, because by that point, we will have had another meeting. I will put this on the agenda, and all 30 of the TexCom members can weigh in, and at least you can get a larger sample size than just one person.
And I suggest we put this over.
So I don't think we need a vote on that, Brian. We'll just put it over to a future meeting.
No, but I do see Kristen raising her hand.
Oh, I'm sorry.
I was just going to point out that Mr. Sterling's here, and I don't know if he has anything he'd like to add. I did have a couple of things that I wanted to sort of tag on. Commissioner McAllister was talking about how often this is used. Much of the case law on these things is quite old. There haven't been very many recent cases on these protections. So it may be that they were used much more in the past, and consistent with what Mr. Anderson's experience has been, it might be that they're not being as used as frequently today.
So then I would be very interested to hear from TexCom whether this is a solution in search of a problem.
Yeah, and the only thing I would add to that is that if we're gonna hit pause and make that inquiry, I would probably ask Kristen to also reach out to the Judges Association and maybe give some thought to whether there's a committee of Judicial Council that might have thoughts on it. Just beat the bushes a little bit more so that we can get more of a practical take on whether it's a problem that really needs to be addressed.
Okay, so we're in broad agreement that we'll just push this over to a future meeting, Brian? Is that sufficient for your purposes?
Yeah. Is that okay,
Okay.
Kristen? Was there anything you needed?
Well, no, I was just wondering if Mr. Sterling had anything he wanted to add on this. But
Nate?
that's it.
Am I unmuted?
Yes.
Okay. I think the discussion really, I think, hit all the major policies that you'll have to consider here. Yeah, obviously, how frequent something like one of these protections needs to be invoked is an important factor. And as I recall, we did not have any good data on that. There are cases, but as Kristen points out, the case law, at least appellate case law, is older. If you have an opportunity to poll the judges, as you're talking about, that would give us some useful information. Yes, you're correct, Mr. Chair, that the whole object of these non-probate transfer devices is to simplify the transfer of death process, avoid many of the complexities of probate proceedings. But what happened is we've now basically converted our entire transfer of death mechanism to a non-probate mechanism, at least if the estate is well planned. And by doing that, we've managed to bypass basically all the protections that were built into the prior law. So now the question is, taking your 10,000 foot view, is that really where we want to be? Skimming through Kristen's memo, I thought she has some interesting points about, well, maybe it would become very complex if we try to claw back many of these individual transfers into a probate type of proceeding. That would obviously create inequities depending on how it was done. But if you look at someone who does have a well-planned estate with a comprehensive trust, that fulfills basically the same function that the old will and probate used to fulfill. And so you start to wonder whether it might not be appropriate to have some protections built into a device like that. So yes, there could be a balance there to look at. Clearly, so I guess I wasn't there when you decided to not look at creditor rights that are bypassed by non-probate transfers. It's clear that that's a much more common problem, and you see that all the time. Whether it's important to have some of these family protections in an era of non-probate transfers because you don't see them used very much. Well, that's hard to say. You can't get statistics on it because those non-probate protections, those family protections are not available when you have a non-probate transfer. So it's like a circular kind of argument or investigation. So I'm not sure how much you can tell about that. But as to the point of the purpose of that, I don't think, you know, your assumption or comment, Mr. Chair, was that, well, this is to protect the family members from inadvertence by the decedent. I don't think that's really true. I think, and in fact, there are mechanisms in the law to reform some of these instruments if there was an inadvertent failure to take care of someone who would be a natural object of the decedent's bounty. I think it really is intended to protect dependents of the decedent from the decedent's intentional disposition of property to other people and not to take care of his dependents. And so, you know, how often that occurs, I can't say, and I think it is important to make that inquiry.
Okay, we'll table this for a future meeting. I won't say for the next meeting because our next meeting is going to be a month from now, and that's probably going to be too soon.
I think so.
Yeah, that's another consequence of going to monthly meetings is that it's going to be a little bit harder to get other organizations to turn around their comments in such a short window. So that's the kind of thing where it might make sense to kick it out 2 meetings.
And with regard to Commissioner Simpson's dichotomy between equity and simplicity, I don't know if it's necessarily equity. We live in a complicated state where people have 3 or 4 wives. So you may perceive that an ex-wife and a previous family is more deserving of your property than your current one. And maybe that's something we should let people have because the past wife and family may have be in a more destitute position than the current one. So I don't know if it's purely inequitable to allow the family protections to be removed. But any further comments from anybody? Kristen, anything else on this memo?
No, I think that's it. I've got some pretty clear direction about how to proceed, so I appreciate that. Thank you, commissioners.
Thank you. Turning to item 10, disposition of estate without administration, Memorandum 2020-18.
That's mine. And I will be quick unless you decide otherwise. This is a draft of a recommendation. So this is a study we've been working on. We put out a tentative recommendation. We got comment. The commission decided to make some changes in response to the comment. Those changes have been implemented in this draft. And on page 2 of the covering memo, I've got a bullet list of those changes and where they exist in the draft, by section number anyway. So hopefully you've had a chance to look at that list and check to see that the recommendation is consistent with what you all decided. And if so, I would ask you to approve it as a final recommendation, and that would require a roll call vote. That said, if any of you have any questions about any of these issues and how they were implemented, we can talk about it.
Any commissioners, any audience members? Nobody at all. Brian, for the new commissioners, do you want to explain now that we're going to issue this final recommendation, what's the timeline and process for these things going forward? Because some new commissioners may not be aware of what happens next.
So when we approve a final recommendation, it's going to be distributed to the legislature and governor, which is a formal process. And it's not every member of the legislature, they're designated recipients. So we'll do that. We're also going to prepare it for publication in our hard volume compilations, which in past years we did one every year. In the last few years it's slipped a little bit. We've had a couple of 2-year volumes, but it'll be in the pipeline for that. It'll be on our website, and it will have the effect of a commission recommendation. And the next step would be for me to work with people in the legislature who I think would be interested in this topic, and see if I can find a member who would be willing to introduce a bill to implement it. And then once that happens, then it gets introduced, and the staff will work with the author's office to provide assistance with background matters. We don't do advocacy, so we won't like go out and meet with members about it or anything like that. But we routinely help do things like draft worksheets for the committees that are going to consider it, help them draft fact sheets, and then we show up at hearings as a background witness. And if the members of the committee have any questions, we'll answer them. We don't advocate for passage, we just explain.
Brian,
Yeah.
to be clear for people who maybe don't follow the legislative process like Mr. Simpson and I have, you wouldn't be doing that until the next year in January.
That would be the
author.
introduction. We
Well, yeah.
typically start shopping for authors at the end of the calendar year if we have a recommendation. So it'd be like November,
right.
around that time. This time, who knows? Because I don't know what the legislature is going to be looking like next year. So I don't know whether members are going to continue to have sharply reduced bill loads. If they do, then we may take a pass on it for a year and wait till things get more normal. But if they're back to normal, then we'll just proceed as we usually do. So again,
I would move it as a final.
okay.
Okay, well, I hear a motion. Second, anybody?
Second.
Okay, all those voting in favor of issuing this final recommendation as the first step to it becoming a statute, say aye, raise your hand. Aye.
Aye.
All those opposed, nay. Please raise your hand now and say nay. Seeing none, any abstentions? I see none. Okay, let's move on to the last item, state and local agency access to customer information from communication service providers. Any audience members, please raise your hand. I see none. Go ahead, Brian.
Okay, so this one requires a little bit of a historical refresher, although I tried to do that in the memo. Several years ago, in 2013, the legislature assigned us a study of state and local agency access to electronic communication customer information or something like that. And it had two components to it. One was essentially wiretapping, interception, surveillance, and government's access to communications in that context. And the other piece was interruption, government actually suspending communication service in an emergency. We started with the surveillance piece. It required a lot of research, a lot of discussion and analysis. We were looking at all, as directed by the statute, to look at all the statutory and constitutional implications and whether or not existing law needed to be adjusted to reflect the more modern technologies involved in electronic communication. So we did that. It took us a little over a year to work our way through that. And we were right on the verge of pivoting towards identifying problems in the law that we would recommend reforms to address. And right when we were at that point in our process, Senator Leno introduced a bill that took the wind out of our sails. He addressed most of the issues that we had identified in our study as being problematic. As I said this morning, when that happened, when that bill was introduced, we had to make a decision about how we were going to respond. Because if we had continued with our process of discussing problems in the law and how they should be addressed, on the one hand, we might be seen as giving support to the bill, by concurring in the analysis that there were certain problems. And it's also possible we might have been cited as by the opposition to the bill, where we proposed a different approach than the one used in the bill. So it was really thorny, and the commission's decision was to postpone the phase of the study that would involve like normative analysis and recommendations. Instead, what we did was we prepared an information-only report that presented our findings with respect to statutory and constitutional law, but without making any recommendations for reform. And the commission instead decided to transition to working on the second matter that had been assigned to us, government interruption of communications. And we worked on that and completed it. The recommendation led to an enactment. And we have been kicking this surveillance can down the road ever since. Each year when we consider our work priorities, we think about like, is the time ripe yet? Because, and especially in the first year or two after enactment of CAL-ECPA, the California's Electronic Communication Privacy Act, there were a lot of follow-up bills. People were identifying gaps or shortcomings and recommending cleanup or enhancement bills. And so we just, for several years, decided to just stay out of it. And I think that the dust has settled sufficiently now that we could return to this topic and finish it. As the memo explains, most of the big issues that we were on the cusp of identifying have already been solved by that bill and the subsequent legislation. So we're left with just a handful of things at the margins. And, you know, I don't think that anyone but us would be looking at these issues. So I don't think there's a problem now if we were to proceed and dispose of them. I don't know, you know, for each of them, I don't know the extent to which they would be welcomed or appreciated or opposed. And I think that's something that we can learn through our study process. And so this memo begins to lay out and describe what those issues are. I ran out of time, so I didn't describe the last two in more than just a very summary form. And then subsequent to the memo going out, we got a letter from ACLU Northern California commenting on the memo. And so what I'll do is I'll just walk through the issues and see what kind of reaction you have to them, and also discuss what ACLU had to say about them.
Brian, before you start, Brian, I just want to let everybody know I have to get off in about 12 minutes. So
Okay.
we'll be back on after that. Thanks.
Okay.
So Brian, there won't be specific decisions needed. You just, at the end, are going to ask whether or not to continue studying these issues right now.
Well, I mean, there might be some situations where on the specific proposal, you think, no, let's not do that. And so I'll probably ask the question issue by issue rather than at the end.
Commissioner, can I ask if, I mean, is there a reason we need to go through it issue by issue? Doesn't it seem a little more time efficient to just authorize staff to go ahead and explore these issues in more detail?
Well, if you're comfortable with that.
Because when I read through this menu, and I got to the end, that seemed to be the decision point for the commission, and I'm fine with studying this further. I do see some issues that seem like they deserve some cleanup.
I mean, I guess the only thing I would say is that in response to the letter from ACLU, I think a couple of the issues would have to take a slightly different direction if you share their concern. And so I don't think the memo by itself is the whole picture. I think and this letter was received late enough that I didn't present analysis of it in the covering memo.
That's something that staff can incorporate into their analysis.
You want to do it that way?
Unless anybody has an objection.
No, I think because we're going to meet next month,
Yeah.
then I think we probably are okay. Because honestly, Brian, you had mentioned for your process proposal that maybe that you kind of advance issues based on staff recommendations, and we didn't touch on it. But I do think it will make things more efficient.
I'm happy to do it that way. And the other thing I was going to say before, what never got to this point, is that, you know, if people feel like they're flagging and just want to be done with this meeting, that's legitimate too. I mean, I think that's a good
Commissioner McAllister.
That's fine with me. I just wanted to ask Brian if there was a specific issue that was addressed by the ACLU that you would like to bring to our attention, you know, in a brief manner, or however, for us to be considering between now and the next meeting. If there's something that's really urgent, otherwise, I'm happy to go with the consensus of the other commission.
No, I think that the most significant difference between my analysis and the position taken by ACLU is something that cannot be briefly explained. I think it's complicated.
Commissioner Borivine.
But the ACLU is on the line as an attendee. Should we give him the opportunity to speak?
Oh, great. Sure. Yeah, he hadn't been before.
Okay, his hand is not raised, but Chris from ACLU, do you wish to be heard?
All right, I'm going to allow it. I allow it. You have to unmute your mic, though.
Wonderful. Thank you.
Yeah.
So my apologies. I've been jumping onto a few things today. So I just hopped on a second ago, and I think I caught Brian mentioning that our analysis of the situation and the CLRCs was a bit different, and the invitation was for me to explain where our departure was. Is that?
No, I think the direction the commission was going before you joined us was they were inclined to put this over till our next meeting, which would be a month from now, to give more time to sort of do more justice to the issues you raised in your letter than we were able to with the short time we had.
I am happy with that. I certainly don't need to urge the commission to rush into this. If more time would be helpful for deliberation, I will also hopefully not be jumping back and forth between quite as many Zooms at next time, although that's hard to promise these days. But I appreciate the time and consideration you gave to our thoughts, and would be happy to continue discussing them if it's helpful now at all, if not on the next meeting or in the interim.
I think we're maybe saturated. We've not been jumping around between Zoom meetings. We've been in this one since 9:30. So I think it probably makes sense to do as the commission was inclined to do, and I will just talk to you offline and write a memo that sort of lays out in more detail the issues and where I see things slightly differently than you do, and we can bring it up again at the next meeting.
Happy to continue the conversation that way. That sounds like a great plan to me.
Brian, it may be helpful for the new commissioners if you flag or send links to some of the old documents from when we were doing this a couple of years ago, because we had some very long, comprehensive documents on this topic, and I've lost track of what numbers they were, and it'd be good to have that background, and would minimize your work on having explained that.
Well, I am going to do you one better and say that on page 4 at the top, I say commissioners who were not part of the earlier phase of this study or who need a refresher may wish to read the commission's informational report. So that was our formal report on the status of the law at that time. And so the footnote has a link to where you can find it. If anyone has trouble with that or would like the convenience of a direct link being emailed, I'd be happy to do that. It also points out the memo 2015-51 on certain pages had a very summary analysis of what Cal-ECPA had accomplished when it was first enacted. And if any member of the commission wants to talk to me about any of this, because I know it's heady stuff, even for lawyers, and I'm happy to talk offline.
And Brian, if you could check, is the Electronic Frontier Foundation getting our memos on this? Is there sort of like the ACLU of the electronic world?
Yeah, they should be, but I'll double check.
Okay.
They were back when we were in our first go round. But
yeah, I seem to recall that, and I'm surprised if they don't rejoin the conversation.
Well, like I said, these issues that we're addressing are at the margins. ACLU and EFF did the heavy lifting already.
Okay.
I will say that ACLU and EFF are in regular conversation about these topics. We did not actually have a robust conversation about this, in part because there's a consumer privacy law that is consuming much of our bandwidth right now. But we will I'd be happy to be part of the conversation with EFF, or you can carry that on independently. We are not always in perfect lockstep, so they may have a different perspective, and more perspective is always appreciated.
Anything else from any commissioners or audience members on anything on the agenda? Now, Brian, before we break, do we need to pick a date certain, or are you going to propose some dates for the next meeting?
I think it probably makes sense to just canvass everybody about availability about a month out, and then see from the responses whether there's an obviously good date and go from there.
Okay, great. Let me, I was realizing, let me explain for the new commissioners that Nate Sterling, the reason we keep talking about him is he, as I understand, was the heart and soul of the commission, was on the commission for decades, became executive secretary of the commission. We gave him an award in recognition for his many years of service. And that's why we keep asking him what to do, because he knows and we don't necessarily do. Thank you for attending. Any other matters whatsoever? Okay, thank you, everyone. The seems have gone fairly well. So do I hear a motion to adjourn?
I'll make it.
I thought we were going to canvas dates. No?
We're going to do what?
No,
I
no,
thought
they'll
we
do
were
that
going to canvas dates for the next meeting.
privately.
Oh, okay.
Yeah, just
Okay.
email. I'll do email.
Okay.
I second the motion.
Okay.
You guys are running out. Happy Memorial Day.
All those in favor of adjourning, say aye. Aye.
Bye.
Okay. See you next month.
Bye.
All right, bye-bye.
You hanging on, Kristen? All right.